Hi, my name is Robert Buckholz and my business partner Andy Scott, principal partners of Scott Robertson Associates, background screening company. Today we're going to talk about a little bit about background screening processes for our clients, both employment and tenant areas. Andy, one of the first things that we want to talk about is we're not attorneys.
And we don't give out legal advice either. So anything that you hear from us today on this short video, please run it by your counsel so they can verify that what we are saying is accurate. We don't provide any legal advice.
And each attorney will want to kind of adjust some of the things that we may tell you according to your own business practices. So it's always a good business practice to consult with your individual corporate attorney in regards to any legal issue. But we are the background guys. We're a background screening company, and we've been in business for 9 years. We know a little bit about the background screening process and the law. And in that particular regard, we want to talk about some issues. The first issue is adverse action. Andy, adverse action has a lot of implications.
Sure. As an employer and as a landlord, if you pull a criminal record or another type of record on a consumer that's going to impact your decision to either lease to them or to hire them, you have to notify that particular applicant through what we call a pre-adverse action letter. Pre-adverse action letters are specifically for employers. And what does that mean? That means that you send a letter along with a copy of the consumer report or the background report, which contains the derogatory information that may impact your decision making as to hiring that individual, along with a summary of their rights per the Fair Credit Reporting Act, and you send it to that applicant. That applicant then has an opportunity to review that report and give them an opportunity to dispute the record if it indeed is not accurate. Now that's another topic we're going to talk about, disputing. So with that being said, an pre-adverse action letter must be sent to the applicant before you make a hiring decision. And you must give them a reasonable period of time based on the Fair Credit Reporting Act language. In the business, it's been determined that a reasonable period of time is between 5 and 7 business days. And then once that happens, Robert, what's the next thing that the client has to do?
Well, the client sends out the pre-adverse action, and we're talking about it in the employment arena right now. Send out the pre-adverse action letter. The applicant receives it, reviews a copy of the consumer report. As Andy says, has an opportunity to dispute or to clarify any particular issue. If the applicant comes back, obviously you should direct them to your consumer reporting agency, hopefully Scott Robertson Associates, and we will work with them to correct any deficiency in the report. If the applicant does not respond within the reasonable 5 to 7 business day period, then the employer is required to send the applicant what's known as an adverse action letter, stating that they were not going to be hired as a result of the background check, either in whole or in part. And then once again, that applicant is disqualified from being hiring. See, it's important that when reviewing a consumer report or a background check that contains a conviction, to realize that the conviction is only a part of that interview process. There's a lot more to it, and the EEOC, Andy, has some specific guidelines.
And the EEOC, the Equal Employment Opportunity Commission, sent out a letter of guidance to employers around June of 2012, and pretty much has warned employers that they should not arbitrarily decline a applicant simply because they have a conviction, a criminal conviction. The letter of intent suggests to the employer that the employer should then have another interview and interview the applicant to talk about the nature of the crime, how old is the crime, circumstances surrounding the crime, and get more information before they make a decision not to hire the individual. So although it's not required by the Fair Credit Reporting Act, the EEOC has suggested that employers take a little bit more time to learn more about an applicant who may have a criminal conviction. So that's something very important to be aware of. Once you have that interview, then obviously, of course, you can submit the adverse action letter if it's not to your liking, meaning the explanation. Keep in mind, though, that the EEOC also wants to make sure that, this sounds strange, the crime is job related to the actual position the person is applying for. So let's say the individual is applying to sweep the floors and be a janitor, and maybe their conviction dealt with perhaps animal cruelty. The two are not job related. So animal cruelty, and you have somebody who's cleaning and in a janitorial service, that's what the EEOC wants you to take a look at as well. There's another thing that's a bit more technical called business necessity, which means that an individual cannot have a certain record based upon the specific job they are doing, and it's absolutely critical that they don't have a criminal record that is job related to that position. For example, if you're hiring somebody that's going to be an accountant in your firm and they have a fraud conviction, that is business necessity, meaning you would not want and should not hire somebody that has a fraud conviction and they're being placed in a position of authority over money and accounting. So that's just a brief example. These are the types of things that need to be discussed with your HR manager as well as with your corporate counsel. So with that, Robert, and we've talked about the pre-adverse action, adverse action requirements by the Fair Credit Reporting Act. And by the way, this is where a lot of employers get sued because they're not following a very simple procedure. But the other issue now is we're coming into, there's really two types of records, criminal records, that employers pay attention to: convictions and arrests. What's the difference between the two?
And there is a big difference between a conviction and arrest. So, and if reviewing the Fair Credit Reporting Act, you'll see that arrest information, or what we would call non-conviction information, is only reportable for 7 years. There is the cutoff. If an individual had been arrested but the case was thrown out, for whatever reason the case was dismissed, the prosecutor decided not to prosecute, that particular arrest is reportable only for 7 years. It's a non-conviction information. Conviction information, however, Andy, is reported according to the Fair Credit Reporting Act without time limit. And in some instances, then again, that's where employers kind of run a little bit afoul, because now they're taking or adopting a business policy that says, if you were ever convicted of a felony, we will not hire you. And that particular business policy will run afoul of the Equal Employment Opportunity Commission. And so there has to be some degree of judiciousness in regards to handling that particular case. Old cases, and when we report cases, surprisingly, we can look back years. Andy, we had a case the other day. There was a misdemeanor theft case back in 1978. It's a misdemeanor lower case. It's 1978. I mean, this case is almost 40 years old.
Sure. And
an employer should not use that case as a reason not to hire that particular applicant, especially if in the last 25 or 30 years that person has had no criminal history. That case is so old, it should just, in our opinion, be ignored.
Exactly, and the client did want to know about that. We did mention to the client with regards to the length or the age of that record and how it currently relates to the position the individual is being employed at. But obviously, we don't make hiring decisions. We just wanted to inform our client that the age of a record should be considered relative to making a derogatory recommendation for employment or leasing purposes. And with that, Rob, the issue of disputes, when an applicant sees their consumer report and they say, this isn't me, or I dispute that this was actually my record, there's a process that has to go into place, and that process is an investigation process which we handle on our side, and that process includes our folks initiating an investigation, and then we determine if the record is indeed valid or invalid, and how long do we have to do that investigation?
Well, you have 30 days to do that investigation, but we initiate that investigation immediately.
Yes.
And surprisingly, while it doesn't happen very often, it does happen that an applicant reviews a consumer report that lists a conviction, and the applicant will come back to us and say, oh, by the way, that particular conviction has been expunged by the court. The county court or the court record doesn't reflect the expungement, but the applicant is able to produce an order from the court expunging that record. What do we do? How does that happen?
Well, we wind up going back to either the court of original jurisdiction that reported it, and we provide them in writing, along with a copy of that expungement order, that this is the expungement order and that record should be removed from their repositories. We also have some vendors that provide us with database information, and we do the same thing. We contact that vendor, we give them the expungement order, and then they have a matter of, within that 30-day time frame, to remove that record from the repository. And although it's rare, it does happen often enough, and it's the right thing to do. So with regards to that dispute process, keep in mind that if you are looking at this individual to hire, and that individual disputes the record, you should not fill that vacant position until the dispute is resolved. So that's something you should run by your attorney as to how you would do that and what's your business process. But it's strongly recommended that you don't fill the position until the dispute's been resolved.
And in cases of dispute, be it on the credit report, or on the criminal report, or perhaps on a civil judgment or a lien, the best people to resolve that dispute for you is, in fact, your consumer reporting agency, Scott Robertson Associates. We work very closely with our client, and we work very closely with those applicants to resolve those particular disputes. We're equipped to do that, certainly much better equipped than any of our employer clients.
Sure.
And one more thing I want to, before we go one step further, one thing I wanted to point out is that we talked about employers, we talked about EEOC. What about on the tenant screening side of the house? Can we touch just very briefly on the tenant screening? How does all this stuff affect a tenant or a property management company or a board of directors for an HOA?
Sure. With regards to denying somebody that is a tenant in a particular homeowners association or condominium association, you need to be very careful. First and foremost, there is no pre-adverse action that you have to notify the tenant relative to there's a derogatory piece of information on their consumer report. But if you do decide that based on the consumer report you're going to deny them tenancy, then you have to send them an adverse action letter. And in that adverse action letter, you have to provide them with their credit score. By law now, you have to provide them with their credit score. And then you send it to them via mail or whichever way you're going to get that to them. And keep in mind now, if they dispute it, then that 30-day window goes into effect. And the other thing that's happening, and that's with the HUD and the requirements that HUD is now asking landlords to pay attention to, which is very similar to the letter of guidance we've spoken earlier about, relative to if there's a record and there's a conviction, give the tenant an opportunity to discuss the circumstances around that conviction.
Right. So, and it really goes back to the a specific American justice ideal, and that is what they call due process. That an individual has a right to speak about something that may be derogatory in their particular record. They should have an opportunity to offer explanation, and that's basically what EEOC is saying, and that's basically now what HUD is saying in regards to either employment or tenancy. So these are a couple of interesting things. We kind of went a little bit further along with that. Certainly, if you have a question about anything that we discuss, number one, remember you can always refer to, and you should refer to, corporate counsel. Two, call us here at Scott Robertson Associates, and we'll be happy to talk to you, Andy or myself.
Sure. Our number is 888-605-4265. And just to recap, we discussed pre-adverse action letters to consumers who may have a derogatory information on their consumer report. We discussed the requirement of adverse action letters. We talked about what's the difference between an arrest and a conviction, and then we reviewed the dispute process. Do not hesitate to contact us, and we look forward to another educational video in the future.
Thank you. Have a great day.